Hi, my name is Michael Kline. I'm an attorney with the law firm of Wasserman, Comden, Castleman, and Essenston in Tarzana, California, and the title of this presentation is The Effective Use of Technology in Litigation. New York attorneys, this is a CLE accredited course, and I'll be providing you with a verbal verification code towards the end of the presentation. Now, a little bit about me before we begin. As you can see up here, I was established in 1975. At the time of this taping, I'm 35. And my firm was established in 1976, so they have, I have one more year on them than they have on me, but I guarantee you that as a full-service law firm, they have a ton more experience and knowledge than I do, although I'm not too shabby. I am a graduate of the Pennsylvania State University, circa 1997, and Pepperdine University School of Law as of 2000. Here at the firm, we have approximately 35 attorneys. I work out of the Tarzana, California office, although we also have offices in Oxnard and Alhambra. Now, while Wasserman, Comden, Castleman, and Essenston is a full-service law firm, my specialty for many years, before the last one or two, I'd say, was civil business litigation. Like many of you, I'm sure, go into court, file complaints or answers, take depositions, do discovery, etc. However, over recent years, I've discovered that with the progress of modern technology and the way things are going, I have an aptitude for programs and computers, and I can put together a PC from scratch and things like that. And I found more and more that people in my firm were coming to me and asking me for assistance, either everything from how to right-click on a Mac to how to do some more advanced things on a computer. And as time has gone by, I've noticed that some of the skills that I have picked up because I am a technophile have translated quite successfully over into the realm of civil litigation. So as part of that, I've expanded my practice. Over the last few years, I've developed a specialty in assisting other attorneys in creating presentations for trial, either through the use of Keynote or what you might call PowerPoint. I have second-chaired trials for other attorneys. And help them present evidence through the use of on a computer and through Adobe Acrobat Pro is one that I like to use. And on occasion, I have sat down with others, and certainly at my firm, and taken them through how to use it on their own. For those attorneys that maybe are a little bit more afraid of technology than others, but do want to get comfortable with these technologies so they don't have to pay someone else to do it. And I have found that through the use of technology, an attorney can be far more effective in reaching their audience than those that are still using the old Elmo or using that pad and paper up on the board. And I think that as I take you through these next steps, you'll see exactly why that's the case. Now, as I said, my firm is a full-service law firm. It's not my firm, I work there. We are full service, and I have worked at other places before, and my interest in technology and my desire to help those that I've worked with incorporate that into their practice has led to this age-old conflict at times that I've called it up until I've been here. And that is, well, how are we going to use that? What good is a computer or an iPad or an iPhone in our practice? That would be the response I would get, because every single time I said, hey, we're doing this, but we could be doing it better. We could be doing it quicker. We could be doing it at a lower cost. And the response I get would always be the same. Well, if it ain't broke, don't fix it. Why would we spend money to fix a problem that doesn't exist? Everybody here is fine using Windows XP. Everybody's fine using Word 2003. We're doing things great. We're making money. We have large houses in the Hollywood Hills. Why should I spend extra money and reduce my profit margin if it ain't broke? I never knew how to answer that until I started putting this presentation together and the events that preceded it that led me to do it. And the answer that I now have, and I didn't realize it before, is, well, it is broke. It's just the people that are making these decisions, and many of you out there probably as well, don't know how broken it is. By incorporating these technologies, and I understand that there is a learning curve here, that you may not be comfortable with picking up an iPad and putting your evidence on a screen. You may not be comfortable or even know of many of the applications that I'm going to be discussing today. But the learning curve that you may have and the time that you may take to learn how to use these will be far, far outweighed by the time and money you will save not only for yourselves, for your clients, when you put these things together over the alternatives. If everybody thought that way in the very beginning, nobody would be on a computer. And that's an important point. An even more important point is that if you are open to this idea of getting over that initial learning curve and adopting these technologies, what I believe you will discover is that your message will be far, far more effective. And that is why, after a decade or so in the practice of law, I've decided to create a presentation. This is the first in a series that I give entitled The Top 10 Rules and Reasons for Using Tech at Trial. Now, you'll note that the program today is called Effective Use of Technology in Litigation. So why am I now talking about rules and reasons for using tech at trial? Well, the effectiveness of the technology and your use of it is the key point that you're going to see throughout this presentation, because no person, no matter how technically proficient they may be, is going to be able to get their message delivered and do it well unless they know how to use that technology effectively. And the only way you're going to know how to do that is if you follow these rules and you understand the reasons behind them. Now, many of you are probably expecting a bunch of programs and ideas. What software should we use? What hardware should we use? And I will definitely be talking about that. But the primary focus of this, because many of you, I am sure, already have a computer. Most of you, if not all. Most of you, if not all of you, have your software already. And just want to understand how you can tweak things a little bit without a complete overhaul. So with that in mind, my goal here is to use examples from the programs that you likely have already and to show you how to use that technology effectively. I'm going to show you rules, I'm going to show you reasons, couple little hints and tricks as well as we go. So, without further ado, number one, tell a story. As attorneys, like it or not, that's what we do every single day. We probably don't realize it. It was something that a lot of us knew and it had at the forefront of our minds in law school, and we wanted to be that litigator like the folks on pick a sitcom or a TV show like LA Law. We saw LA Law, it made us want to be an attorney, and they would always go in and tell these compelling stories. And we got into the practice of law and realized that it was a lot of the same things over and over again, and we'd write our motions, we have our introduction and our statement of facts and conclusion, but we forget, most of us forget, as we practice law on a day-to-day basis, that at the end of the day, all we're doing is we're telling stories to other people in the hope that they will see our point of view. So in order to figure out how to use technology to tell a story effectively, I went to Nancy Duarte. Ms. Duarte is the CEO of Duarte Design, Inc., and she's also a contributor for CNN's opinion website. And she was asked in one of her articles, how does a great presentation reach its audience? The answers, when I read this article, I found intriguing, because we want to make sure that our presentations and our use of technology reaches its audience. But look at what she says. She used words like, tell a compelling and convincing narrative, lure and relure your audience, keep their attention, connect with them, move with them on a journey to your perspective. Now, ladies and gentlemen, these are not concepts that attorneys deal with on the day-to-day basis and are on the forefront of their mind. These are, for lack of a better expression, artsy-fartsy terms, aren't they? What transactional attorney, what litigator is going to sit there and say, you know what? When I get in front of that jury, I want to take them on a journey towards my perspective. No. You want to give them the elements, and you want to give them the facts, and you want to put it together and show them you're right. But the only way you can do that is by taking them on that journey. And remember that when you tell a story, it has that chronological order, a beginning, a middle, and the end. And there is a certain artistic, emotional component. If you're going to convince that judge or that jury, or you're going to convince your client even of what you're trying to say, you've got to be able to connect with them on a whole different level than the intellectual one that you're used to dealing with. Well, technology will help you do that. And you have to remember that as you're using the technology, because for as focused as you may be on making sure that all of those jury instruction elements are set forth in that PowerPoint, or the evidence that you're going to be presenting on that screen has everything that you want, if you don't remember that all of this is part of storytelling, it's not going to be effective. You're not going to reach your audience, and you won't be telling a story. And the reason why I bring all this up is because, as Ms. Duarte put it, all of these things are designed to do one thing: maximum audience comprehension. They are designed to create maximum audience comprehension. Isn't that the goal of every brief that we draft? Make sure they get it. Make sure that they agree with our point of view. Make sure that every single word that we use is understood, and that when the reader or whoever's listening to what you're saying or whoever's watching what you're doing understands those issues, that they side with you and not the other side. This applies to what we do. And she wasn't talking about us. And I think there is one image that I have found that just absolutely sums up the essence of this message. And it's this. I love this image. Why? Because that guy with his silly little hat and his crab claw hands has maximum audience comprehension. He is telling a compelling narrative. He is taking them on a journey towards the perspective that he wants to take them on. Now, is his job far different than ours? You bet. Is he using technology? Nope. He's not using technology. But you should, because you're not him. Your audience is not a bunch of kindergarten and first graders, and you have a far more complex message to get across and far more complex issues to deal with. So by just sitting there and putting on a funny hat and going like this, it's not going to get you where you need to go most of the time. And most of us, even some of the best trial attorneys, are not the best public speakers. We're not the best at orally conveying our message. Some of us do better writing it down. Some of us do better orally and can't write it down. But we need to make sure we connect with our audience. At the same time, while he may know the very basics about who these kids are, what they like and what they don't, as attorneys, we have to deal with this nameless, faceless sea of human beings. We don't quite know what their backgrounds are. We don't know what they might respond to, what might interest them, what might turn them off. So we have to be very, very careful. It's far different than the man with the funny hat. Now throw this into the equation. This is something that quite frankly shocked me. 35% of high school seniors today are reading at a below proficient level. What does that mean? Well, they pick up your brief and they try to understand it, you might be out of luck. And if all you're doing is you're taking that brief and you're taking that evidence and you're going up and you're trying to explain it for an hour in front of a jury, say, or a client, it's going to be right over their head. So how do we bridge that gap? How do we make sure that from the most intellectual of judges to the most rudimentary of thinkers, that we've taken the exact same message and we've maximized our audience comprehension? This is how we do it. We use computers and we use mobile devices like the iPad and iPhone. And yes, I am Mac-centric. You can see it. I am unabashedly a Mac fan. This applies to the PC world as well, so don't be intimidated. If we use these devices and we use the applications on these devices in order to reach our audience, we will do a far better job than those who don't. Because remember, these were designed to make life easier. We forget that as well. Everybody likes to complain about blue screens of death, which don't happen on a Mac. And all these other problems, how long it takes, how I don't know what to do and I messed this up and how do I get this back and I've lost my data. The computer was designed to make things easier for us. And as an offshoot, mobile devices and